Let's now walk through the notes and problems following Iqbal. We already covered some of this material when going through the case. However, extra review is helpful because this is very important and difficult material. Let's start by noting the What's New Here box, where the change wrought by Twombly and Iqbal, we'll refer to them together as Twiqbal, is nicely and concisely summarized. What are the key holdings of Iqbal?
Well, I think Iqbal says that Twombly doesn't just apply to antitrust cases.
Good. What else does Iqbal say? Thomas, what do you think? What can you add?
I think the court in Iqbal said that Twombly covers more than just antitrust cases.
That's true. The Iqbal court said that Twombly extends beyond antitrust and other subcategories of cases. But what else? What was the other important holding? Online student, what can you add? Lisa?
The other thing the court says is for courts to pay attention only to the non-conclusory allegations that seem plausible to the court.
Good. Iqbal extends the formula of Twombly to all complaints, stating that Twombly was not limited to antitrust or other subcategories of cases. And Iqbal instructs courts facing a challenge to a complaint first to disregard conclusory allegations and then to decide whether the remaining non-conclusory allegations add up to a plausible statement of an entitlement to relief given judicial experience and common sense. From now on, the court says, courts should follow that approach when evaluating Rule 12b-6 motions to dismiss. That's the standard of review that now applies in courts around the country. This new rule, as stated in Iqbal, replaces the Conley versus Gibson standard, which many courts had applied for years. With what consequence? How has Twiqbal affected litigation?
It has caused more cases to be dismissed early.
Exactly. Twiqbal has led to considerably more cases being dismissed at the pleading stage than used to happen before these cases were handed down about a decade ago. Okay, so let's go through the notes and problems. In Note 1, we are told that Twombly held a complaint insufficient to withstand a Rule 12b-6 motion. Why? Online student? James?
I'm not sure.
Jane?
I think it's because the complaints in both cases didn't comply with Rule 8A2.
Exactly. The complaints are insufficient because they fail to meet the requirements of stating a claim as specified in Rule 8A2. And 12b-6 motions, as we have seen, can target the sufficiency of the plaintiff's statement under Rule 8A2. Number 2, why did Iqbal's complaint fail? Identify the way in which the majority applied the two-step analysis it describes to the facts of Iqbal. Which allegations were ignored because they were considered conclusory? Lisa, what do you think?
Iqbal says that the defendants intentionally mistreated him because he is Muslim.
Good. In summary, the allegations are that the defendants ordered harsh treatment of the plaintiff Iqbal because of his religion. Which allegations failed the plausibility test? Online student? Jane?
These are the allegations that the defendants personally initiated a policy of targeting Muslims because they are Muslims.
Good. But why were they considered implausible?
Because the court said that Mueller and Ashcroft were just doing their jobs?
Precisely. Those factual allegations were credited, but they were held not to plausibly ground a discrimination claim because there is a much more plausible explanation for the adoption of the policies that had a disproportional or disparate impact on Muslims. Namely, that Mueller and Ashcroft were doing their jobs and simply trying to protect the country following the extraordinary attacks of 9/11. Try to hypothesize what additional facts would have satisfied the majority, taking the complaint past the plausibility threshold. All students, post your answers to this question on the discussion board and then reply to each other's posts. Maybe if the plaintiff came up with some direct evidence of anti-Muslim bias on the part of the named defendants, Mueller and Ashcroft. But that would have been pretty hard to do. It is unlikely that defendants, for example, sent out memos stating that they were purposely starting an anti-Muslim campaign, right? So what other facts might support plaintiff's allegations to make them more plausible? How does Justice Souter's application of the plausibility analysis to these same facts differ from that of the majority? Where do we find that?
That's in his dissenting opinion. He thinks that the facts shouldn't be disregarded.
right. We see in Justice Souter's dissenting opinion that he credits the factual allegations that were disregarded as conclusory by the majority. He says that those allegations of discriminatory intent because of plaintiff's religion should not have been disregarded. The next note says that the standing committee that considers revisions to the federal rules has, over the past several decades, promulgated, and the Supreme Court approved, a number of changes that restrict or stage discovery. The Civil Rules Advisory Committee could have entertained a proposal that would have amended either Rule 8 or Rule 12 to provide for the two-step process prescribed in Twickball. But no such proposal has come. Had there been such a suggestion, the proposed rule would have been subject to extensive comment by the Bar and the Legal Academy, and perhaps to some empirical legal studies designed to assess the nature and dimensions of whatever problem Twickball was designed to address. That did not occur except in the Iqbal briefs. Commentators have argued that the justices should have been more hesitant to reinterpret the civil rules, given the available amendment process. Justice Stevens, dissenting in Twombly, and this part of his dissent is not in the casebook, apparently thought so as well. He wrote, "I would not rewrite the nation's civil procedure textbooks and call into doubt the pleading rules of most of its states without far more informed deliberation as to the costs of doing so. Congress has established a process, a rulemaking process, for revisions of that order." Now, what do you suppose the majority's response to that would be? Online student? I think the majority would say that we didn't change anything at all. All we did was clarify an old dictum from Conley versus Gibson, which was being applied in a way that we think is inconsistent with Rule 8A2. We believe, in other words, that Rule 8A2 requires, and has always required, sufficient facts to nudge the claim over the plausibility threshold. We think that Rule 8A2 has always required that conclusory allegations not be credited. Now, whether or not Rule 8A2 was properly applied over the decades, that really isn't the question. So that's the nature of the debate here. Think through for yourselves whether you find one side or the other side of the debate more convincing. Scholars have been trying to decide this question since the opinion was announced in 2009, and they have disagreed both regarding the answer and the proper methodology to apply. Some have compared courts' motion to dismiss grant rates before and after Twombly and Iqbal were decided, and seen in the stark rise in those rates the lesson that Twombly and Iqbal have really transformed the playing field. Yet, as several other scholars have observed, such studies do not take into account that litigants' behavior was probably changed by the issuance of these decisions as well. How? Jane?
Some plaintiffs may decide not to file a lawsuit, knowing that it cannot withstand a plausibility pleading challenge, or might settle a case soon after filing for fear of a successful motion to dismiss.
Good. Now, what about defendants? Online student? James?
Not sure.
Do you think that defendants might be more or less likely to file a motion to dismiss after Twickball?
More likely?
Why? Do you think defendants might believe that their chances went up or down after Iqbal?
Up?
Why?
I'm not sure.
Online student, can you help James out?
Because the plaintiff has to meet the two prongs now. First, that the plaintiff's claims are not conclusory, and also that they are plausible.
Very good. Recognize that it is really hard to get a good measurement of the effect of Twombly and Iqbal because there are collateral factors, such as plaintiffs' and defendants' behavior, about which we have no data, but which were certainly also affected by these decisions. Note 4B says that judges also seem to be unsure about Iqbal, what Iqbal means in practice. Just as Justices Kennedy and Souter appeared to disagree about which allegations in Iqbal's complaint were conclusory, judges have not distinguished between factual and conclusory allegations in a uniform manner and have assessed plausibility in different ways. Then the note includes this key point. Iqbal, in fact, seems to encourage inconsistency. I would disagree with this. I would say that it could be read to encourage inconsistency insofar as it instructs judges to assess allegations in light of their judicial experience and common sense, but we can't say for certain that that has happened. In any event, why might the introduction of this standard lead to inconsistent application?
Because judges are different and might view things differently.
Good. Do not misunderstand this paragraph to suggest that by introducing judicial experience and common sense into the calculus, that this is now a discretionary judgment. It's not. It's still a question of law. Note 4C says that because the meaning of Twickball has yet to be fully worked out, and because Twombly and Iqbal seem to offer powerful new tools to the defendants, the Twickball motion to dismiss has become a staple of federal civil litigation. Consider this statistic. In the first 32 months after Twombly was decided, judges cited it almost twice as many times as Erie Railroad versus Tompkins, a case that is considered fundamental in federal civil procedure. All right. Also, as of 2015, Iqbal was cited in more than 85,000 cases. It is evidence that these cases have had a major effect on civil litigation. Now let's walk through Note 5, and that will conclude Module 8. Assuming that Iqbal works some important change in pleading practice, and I think that's undeniable, in which cases will it matter? What about a contract dispute?
I don't think it would matter. In a contracts case, the plaintiff might not know why the items fell apart, but the plaintiff will know that it happened and can make a claim in a non-conclusory way and with plausible detail.
Exactly. The point here is that Twickball maybe hasn't had such a big impact on breach of contract actions because the plaintiff knows what they believe the defendant's noncompliance to be, and that's all the plaintiff needs in order to allege a breach of contract. Let's look at Note 5B. In other cases, the plaintiff will have a plausible theory of, for instance, negligence, even if that theory turns out not to be the whole story. Even if you don't know why the defendant ran a red light. Okay, and so a plaintiff in a car accident case is likely to be able to plead that basic fact, which in and of itself is enough to give rise to a plausible theory of negligence. So in my understanding, Twickball has not led to a revolution around the country in car accident cases. These sorts of cases are still able to go forward. Note 5C says the cases where Twickball will cut deepest are those in which the other side, and only the other side, possesses the information that will create or avoid liability. What types of cases are those?
Claims of retaliation, discrimination, and other causes of action dependent on unlawful states of mind may be particularly difficult to plead.
Very good. How can a plaintiff plausibly allege what a defendant's unspoken intentions were? In those cases, properly conducted discovery could reveal that information, but without it, the pleader might not be able to run the dual gauntlet of non-conclusory statements and plausibility. And in such instances, the case might die at the pleading stage. And in this respect, recall again that Rule 9b says that these types of states of mind may be alleged generally. But we're told by the Iqbal majority that while that's true, that doesn't affect our decision. Why again is that? Online student? Jane?
I'm not completely sure, but does it have to do with the requirements of Rule 8A2?
Online student, how would you answer, Jane?
I think Jane is right. Since Rule 8A2 says that to survive a motion to dismiss, the complaint must state sufficient facts to state a claim that is plausible on its face.
Good. It's naturally going to be destabilizing when you get a landmark decision written by Justice Souter for the majority in Twombly, and then 2 years later you get another landmark decision, and the author of the first landmark decision is in dissent, alleging that the majority in the second case has misapplied the holding of the first case. In that scenario, a lot of controversy will ensue about where lines are properly to be drawn, and we've seen that with respect to Twombly and Iqbal. Okay, that concludes Module 8. Again, it is difficult to think of any recent civil procedure cases that have been more important than Twombly and Iqbal, both with respect to their impact on federal civil procedure and with respect to their impact on the number of cases that make their way into the discovery process.